Good afternoon. Welcome to the Long Live Third Parties podcast. Free Press Media Press Inc., a third parties books publisher, sponsors this podcast. I'm Andrew Bouchard. Today I read the case. Libertarian Party of Connecticut versus Lamont, 977 F3D 173, Court of Appeals, 2nd Circuit, 2020. Friends, we are going to talk about the Libertarian Party and other third parties today. So come join me to rejoice about third parties. Once again, we see an example of third parties fighting for their right to get on the ballot. So let's consider what happened here. The record says, quote, the Libertarian Party of Connecticut and two of its affiliated candidates sued the Governor and Secretary of State of Connecticut, arguing that the state violated appellants' First and 14th Amendment rights by requiring candidates for office to collect signatures from electors before appearing on the general election ballot. Appellants sought a preliminary injunction prohibiting the state from enforcing the petitioning laws and requiring it to place all nominated Libertarian Party candidates on the general election ballot. The district court denied the motion for a preliminary injunction on the ground that appellants failed to demonstrate a clear or substantial likelihood of success on the merits. End quote. Friends, that doesn't sound good for our side. Once again, I'd like to point out they invoked the First and 14th Amendments. I see that again and again in these ballot access trials. Way to go. We love third parties here. We also love the First Amendment. We love when you combine the two. The 14th Amendment, combine that as well because that rocks too. The amendments, most of them, rock. So let's rejoice. One thing I've noticed is in these trials, these third-party trials, they're coming really frequently these days, 2020. That's very close to what we are now, 2021. In fact, this was, it said, decided October 2nd, 2020. When I have done the obscenity trial podcast, a lot of them were in the past. Some of these are in the past too. So I'm wondering this. Is it easier to get on the court reporter for ballot access than it is for obscenity? I don't see too many adult obscenity trials these days. But ballot access trials, they're right in the thick of things, right in the moment. So friends, if we want to get in a court reporter that may be on your bucket list, ballot access may be the way to go. And not only ballot access, you can advance the First Amendment while doing that. So it sounds like a win-win scenario, if you ask me. An issue that came up, like it has happened on some other of these cases, was the issue of COVID-19. And they also talk about in this trial how in the state, if the party got 1% in the last election, they automatically on the ballot. If not the case, they have to apply for the signatures to be signed. So in any other circumstance, that would be all there was to it. Those are the two ways. But because of COVID-19, that changed this process in Connecticut. So let's read about that. It says, quote, on March 10th, 2020, the governor of Connecticut declared a public health emergency. Over the following month, the governor issued a series of executive orders designed to reduce the spread of COVID-19. On April 4th, 2020, appellants sued Governor Ned Lamont and Secretary of State Denise Merrill and alleged that Connecticut's petitioning laws was unconstitutional. They sought a preliminary injunction requiring the state to place all nominated Libertarian Party candidates on the November ballot. On May 11, 2020, Governor Lamont issued Executive Order 7LL, which altered Connecticut's petitioning requirements in three ways. First, it reduced the number of signatures required by 30%. Second, it extended the filing deadline by 2 days. Third, it permitted candidates to collect signatures electronically or by mail. End quote. What do you think about those loosenings of restrictions. Do you like those, friends? Do you like that? Do you think they are a good thing? Do you think it makes it easier for third parties? The Libertarian Party here, from what I'm reading, did not think it was enough. They still thought it was too hard to get all those signatures, even though the signatures were much less after COVID. They did discuss how, because of COVID, the way they read one of the executive orders was it prohibited petitioning altogether, because it was addressed to saying the non-essential businesses, which petitioning was, could not do their regular stuff. That sounds like a good argument to me. However, the court did not find that persuasive. The court says later Connecticut would issue some proclamations saying that if they did social distancing, they could do the petitions in person. The court also says here, before this public emergency happened in March, they had a couple of months before then, and then after it was lessened, the restrictions, they still had time. The Libertarians argued gathering signatures by the post office was not efficient. And they also said the Libertarian Party didn't have the apparatus to gather signatures by electronic means. Friends, do you have any experience with this? What do you think about that? To me, I see their point. It would be hard to gather signatures by mail or even electronically. I don't know how this would work doing it in practice. Ultimately, though, they found none of these objections persuasive. The court declared that the state had the right to do this, not only restricting ballots to candidates that had enough appeal, but also after COVID-19 making the restrictions. So they said, therefore, quote, for the foregoing reasons we affirm the judgment of the district court, end quote. Friends, we didn't win this side. What can this teach us? What arguments do we agree with? And how do we keep going despite of them? Whatever the ballot access laws may be, it would be awesome if we can find a way to get to the top. Have you ever signed signatures before? Back in the day, we had the Reform Party at a booth for Free Press Media collect signatures. So that rocked. That rocked, my friends. What about you? What's your experience signing signatures? Do you like mail? Do you think that's legitimate? What about COVID-19 and petitioning in Connecticut or elsewhere? What about electronic signatures? This is good stuff to talk about. It helps us advance third parties. Long live third parties. Goodbye.